Good morning. Are you Karis Antoine?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does, Judge.
And I'm guessing there's a warrant for what?
His bondsman surrendered his bond.
Okay.
And honestly, we thought it was something that was taken care of. They had contacted me. I actually got in touch with Mr. Antoine. He spoke with him, but
Okay.
Yes, because I talked to him Friday and
Okay. That's good. I just wanted to make sure. You're good. Okay. And he'll waive the formal reading of the indictment.
He does, Judge.
Mr. Antoine, in cause number 24 DCCR 1878, you're charged with the third-degree felony offense of injury to a child from September 26th of 2023. And how do you plead to that charge?
okay, good.
You either did it or you didn't do it, guilty or not guilty. Are you pleading guilty freely and voluntarily?
Right here, we're already seeing a red flag. The judge is trying to confirm whether the defendant actually contacted an attorney, and notice how quickly the story falls apart. In court, credibility matters. If you say you spoke to a lawyer and the lawyer is literally sitting in front of you, that's not just awkward, it hurts your standing instantly. Question for you. Should the court keep giving resets when defendants clearly aren't prepared, or is this already pushing patience?
And because you did what they charged you with.
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 5-year deferred adjudicated probation. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Antoine is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report, and that'll give me more information about you and your case, and then we'll come back later for sentencing.
This moment is important. Unlike others, this defendant qualifies for a court-appointed lawyer, which means the judge has determined he meets the financial criteria. That's the legal fork in the road. Either you hire private counsel or the court steps in. Notice the contrast. Preparedness equals progress. Chaos equals delay. Let me ask you, do you think the system is fair here? Or does it reward people who simply know how to speak the court's language?
So, with regard to a bond based on the nature of the plea agreement, Mr. Nichols,
I don't have any objection to that. He has no felony history that I see.
right? Let me look at this affidavit real quick.
The charge itself is for hitting a child with a belt, over discipline, essentially.
Okay. What's the status of that relationship? Do you still live with that child?
I haven't been around him since the case went on.
Okay.
I do see him. I see him with my mom,
Supervision.
her mom,
Okay.
and I really miss my family.
Well, and we'll see how that goes on probation. For now, you're still under that order to have it only supervised, okay?
I understand.
And then you can work up, once you're on probation, hopefully to doing the right classes and everything, and that should be lifted. What I'm going to do, Mr. Antoine, is reduce your bond in your case to $1,000, and I'm going to make that a personal bond. So I think that means, though, that he still has to go, right? Okay, so you're still going to have to go, but as soon as you get to the jail and they process you, you're going to be released without making that bond that I set because of the bondsman getting off your bond. Okay, makes sense?
Yes, ma'am.
It's just, but here's the thing. I'm kind of putting myself out there to make sure that you're gonna do all the right things between now and sentencing, okay? You have been until then, but it looks like you had some issues at some point communicating with your bondsman. It's very important, several things that you have to do between now and when you come back for sentencing.
I got you. Yes, ma'am.
Once you're released from jail, you're gonna get some paperwork today. It's gonna have where probation is. You have to go straight to the probation department, okay? If you get released for some reason later this afternoon and it's too late, then you go first thing tomorrow morning.
Yes, ma'am.
If you don't do that and get that process started for that pre-sentence report, I don't have to accept this plea agreement. So things could be a whole lot worse. Do you understand? If you violate your bond condition and you're around the children or child that you're not supposed to be unsupervised, then obviously I don't have to accept this. Things could be worse. So keep following all of the rules of your bond. Yes.
I have one question. Okay, is it only for that child?
No, I would say at this point, it needs to be all of your children. And then we'll deal with everything when we come back for sentencing, okay? And so that's for everyone, just to make everybody, well, it's not for everybody, it's for me to feel more comfortable until I get the pre-sentence report and I see what all is going on, how many kids you have, where they live, what the situation is, what the recommendations are from probation. So we're only talking about 5 or 6 more weeks.
Yes, ma'am.
But it is
I really have something important to tell you.
What?
I've been raising my 10-month-old for months by himself. So if I have to give him up, I will, because I need to start it for my kids.
Well,
He's a baby. He's been with me since 12. Like,
who, where's the mom?
we don't talk. Since the case going, we don't talk like that. Like my mom and her mom, that's when we meet up. But
I think the court's question is the mother of the 10-month-old the mother of the child in this case?
yes,
So where's the child that was in this case live?
she's with her mom. I don't see them like that. Like we've been separated since I had been arrested, and she stayed with her mom, and I have my own place.
Okay. But it's the same mother of both of your children,
Yes, ma'am.
but the baby lives with you
Yes, ma'am.
and the other child lives with her.
Yes. She got 4 other kids who live with her. I just got one.
Did you go through anything with CPS as far as they I mean, we have an order for some CPS records, but was there anything to CPS get involved?
No, ma'am, I never went through nothing like that.
Okay,
I don't think anything's been provided to us in response to that order.
it doesn't
Judge,
look
so
like it.
maybe
So
there's
maybe that's
still-
because there wasn't anything.
Yeah.
I think it was important that I tell you that I have.
No. I would much rather you be honest, but, and if you're raising, let me look at something real quick.
No, not at all.
Yes, Judge, and just to clarify, the child is, in this case, not his biological child.
Okay, so how many biological children do you have?
3.
No, with her.
Oh, 1.
Just
One with that, where you, and then the other 2, or where are they?
They're all with her, and all my other 2, they're with their moms.
With their moms.
Yes, ma'am.
So this is the only one you have. So there's no big deal. I mean, obviously, you love your stepchildren, but this isn't your own biological child that's the
Right.
subject of this case.
Right.
Okay. Then what I'm going to do as a condition of your bond is order that you not have unsupervised contact with all of the children except the one that you're raising. Okay. If you're raising that child, I'll allow you to continue to do that. You'll get out, make sure that you follow all of those bond conditions. The last thing I was going to tell you is that as a condition of this, if you are arrested for anything between now and when you come back for sentencing, again, I don't have to accept this agreement. Things could be worse. You understand? Okay, we'll see you back at sentencing.
Thank you, Your Honor.
Thanks, Judge.
Thank you. Good morning.
Good morning.
Good morning. And sir, you're Larry Fletcher Jr.?
Yes, ma'am.
And Mr. Fletcher, in cause number 25, DCCR 0838, You're charged with the second-degree felony offense of aggravated assault with a deadly weapon from September 18th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
In cause number 25 DCCR 0839, you're charged with the second-degree felony offense of manslaughter from September 18th of 2024. And what that means is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And then finally, in cause number 21, oh, so we've got a motion to revoke probation in that one. Okay.
Okay, what we could do is just go through the motion at this point. I think Mr. Holman said that he would rather proceed on the MTRP first.
Well, the MTRP is based solely on these allegations.
So it would
and
be a
so-
whole trial.
Yeah. Additionally, if the MTRP was adjudicated prior to this case going to trial, arguably it could foreclose an application for probation by the defendant, so.
Yeah,
That, I'm not worried about that, because if it,
either.
no, I guess I just don't want to. What level offense is that possession? Hold on a second, let me go back here. Second degree. Where's Mr. Coleman to get ready? I mean, a lot of times I want to do the motion first, just because it depends on what the allegations are. I don't want to try to have to find 2 days for a hearing and hear all the evidence that we're then gonna have to turn around and potentially hear in a trial if it's not likely to be dispositive. I don't. Look at one more thing, hold on. Yeah, on this one, I don't know that that makes judicial economy sense. So what I'm inclined to do is set those for trial. But let me do this. It looks like the state has offered you in those 2 cases an 18-year term in prison. Mr. Fletcher, I have a plea bargain rejection that has your signature on it showing that. And that would be 18 years in each of those cases to run concurrently. Is that your understanding of what their offer is?
Yes, ma'am.
And you understand if you go to trial again and you're found guilty, the range of punishment can be up to 20 years in prison. Do you understand?
Yes, ma'am.
I do want to go ahead and do this, and then let's go through the motion. I do want to get pleas of true or not true on that motion, and then what I'll do, Mr. Wilkerson, is get with you and Mr. Coleman in the next week or so. He's got a trial this week that he's getting prepared for, and I will make a decision on whether or not I'm going to go forward on the motion or if we're going to set those cases for trial first. But I want him to be able to have at least his argument in that, so we'll do it that way. So let me go through and find the motion real quick. And Mr. Fletcher, would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You can put your hand down. So in cause.
And this is where the tone shifts. The judge isn't just talking about paperwork anymore. This is a warning. When the court says your bond could be raised or you could go back to jail, that's not procedural, that's personal. This is the moment where excuses stop working. So here's the big question. Is the court being patient, or is this the last warning before consequences hit hard?
Number, there we go, 21-37809. I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation October 11th of 2021 for the second-degree felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
It alleges that you violated your probation. Count 1 alleges that you committed the offense of manslaughter on September 18th of 2024, and is that true or not true?
Not true.
Count 2 alleges that you committed the offense of criminally negligent homicide September 18th of 2024, and is that true or not true?
Not true.
Count 3 alleges that you committed the offense of aggravated assault with a deadly weapon September 18th of 2024, and is that true or not true?
Not true.
Count 4 alleges that you committed the offense of possession of marijuana on July 4th of 2023, and is that true or not true?
True.
Count 5 alleges that you committed the offense of unlawful carrying a weapon on July 4th of 2023, and is that true or not true?
Not true.
All right, did you enter your plea of true to count 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to that count because it's actually true?
Yes, ma'am.
All right, then I'm going to find that you entered your plea of true to count 4 freely and voluntarily, find that count true, find sufficient evidence to find you guilty and revoke your probation. However, what I'm going to do is reset this for now. Just make a note for me to decide what I'm resetting it to and put it on my desk, and I'll get an email or a call, Mr. Wilkerson, with you and Mr. Coleman within the next couple of days, and we'll figure out if I'm going to set it for a hearing and what amount of time that would need on the motion, or if I'm going to set it for trial on the new cases first.
Okay.
All right? And we'll stay in touch with Mr. Wilkerson and your bondsman, and they'll let you know when you need to be back, and he'll let you know what it's going to be for and all of that.
Yes, ma'am.
Okay? You're free to go. We need a print, please. Good morning. Are you Shay Brooks?
Morning, Shy.
Shy, and Mr. Brooks, in cause number 24, DCCR 2034, was previously in court, entered a plea of guilty to evading arrest or detention with the use of a vehicle, received the pre-sentence report. Has everyone had an opportunity to review the report?
Good.
State has jurisdiction.
Any additions or corrections?
Nothing.
Nothing state jurisdiction. We just ask the court probably be in the party.
Thank you, sir. All right, Mr. Brooks, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time follow the agreement that you made with the district attorney and find you guilty of evading arrest or detention with the use of a vehicle. Sentence you to a term of 10 years in prison, but probate that for a term of 10 years. You order to pay the $1,000 fine and to follow all of the rules and conditions of probation. If you do that, this is an excellent opportunity because you don't have the felony conviction. Well, no, it's not. I'm sorry. You do have, for all practical purposes, your case here in court is over if you do everything you're supposed to. And you'll be able to serve that 10-year sentence while you're out on probation. The other side of that, though, is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence that you've